Thank you, Mr. Chairman. Just a very brief call really to echo the comments that my colleagues just made. I guess what would be useful to hear from the Attorney-General, given that, as Leanne Dalzell has said, we stand by the arrangement, obviously, that has been made between the Attorney and his shadow on this matter, and we will support the incorporation of the supplementary order paper at this point. But it would be good, I think, for the House to hear from the Attorney just how the change that is to be made by this supplementary order paper to Part 1A will increase judicial throughput in the district courts. We've heard that there have been a number of acting warrants issued. The number was quoted. That's somehow thought to be a bad thing. It would be good to hear why that is. On one view at least, it might be cheaper to have acting judges on a warrant backfilling in the district courts rather than making up new warrants and having to have all the costs associated with tenured judges sitting on an indefinite basis. The famous quotation about dukes and dreadnoughts comes to mind, sir. If we aren't to have a committee process where we can actually get a properly ventilated argument about whether or not the changes proposed, 16 new judges being paid a significant salary each, being paid significant amounts by way of a charge against the Crown on their support staff, and all the other accoutrements of office that will be required for them, is a significant thing to commit to. As we aren't going to have committee scrutiny of whether that will actually result in better justice in the district courts, it would be good to hear from the Minister and the Chair why he thinks that will be the case, as opposed to the alternatives of, for example, resorting to a mix of the current solution, which is the warranting of acting judges, or indeed perhaps discussing with the judiciary via the appropriate authorities ways in which, at least in the lower courts, we might get more efficient outcomes.
Mr. Chairman.
The Honourable Christopher Finlayson.
So I thank the member for this and begin by expressing my concern on his behalf at the unfortunate flight he had. I must confess my sympathies actually were with him. I was flying recently and I had some urchin kicking my seat, but rather than turn round and upbraid him, I was frightened that what happened to the honourable member would happen to me. So there we have it. But the point that the member makes is a fair one, and I think it's better. The question of temporary judges, of course one is not opposed to them in principle because the system couldn't operate unless they were there. The question really is the number, and when one becomes utterly dependent on them, then I think of the judgment of a Scottish court where the very issue arose, and it was referred to as a very cheap and shabby form of justice. So what I'm trying to do is address that as best I can. The other point that needs to be made is that there has been a growth in the work of the Environment Court because of the particular circumstances of the Employment Court, and the member, as a respected practitioner in that area, knows about that area of the law, rather than we've got two temporary judges of the Employment Court. They also hold warrants as district court judges. So there has been a growth in work since the last time the number went up, and it's a matter that is going to have to be addressed on a regular basis, I imagine. The member didn't raise it, but one concern, if it gets too much bigger, is that we'll be dealing with the largest court in Australasia, and that is something to be borne in mind before we increase it any further, because the administration involved in running such a large court is an important question.